All right, we have reached 10 o'clock, and IT has started our digital recording as well as our streaming audio. So Chief Judge Bartley, I think our judges are on. We'll go ahead and proceed.
Yes, that's fine, Mr. Block.
Good morning. This is the Clerk of the Court, Greg Block, confirming procedures for the oral argument scheduled to be conducted by teleconference this morning. If arguing counsel or a judge drops from this teleconference, we will pause the proceeding and clock until the judge and or counsel is reconnected. In accordance with the instructions previously provided to counsel, we will sound a tone that sounds like this when counsel has 3 minutes remaining in allotted time, and a double tone that sounds like this when counsel's total allotted time expires. Arguing counsel in this case are on the call. Mr. Christian McTurnigan, can you hear me?
Yes, I can.
Thank you. And Ms. Lori Jemison, can you hear me?
Yes, I can.
Thank you. Please stand by while I confirm the judges are on the call. Our presiding judge, Chief Judge Bartley, did you hear both counsel and can you hear me?
Yes to both.
Thank you. Judge Allen, did you hear both counsel and can you hear me?
Yes to both.
Thank you. And Judge Falvey, did you hear both counsel and can you hear me?
Yes to both.
Thank you. Chief Judge Bartley, the call is configured and all participants are now ready to proceed.
Very good, Mr. Block. You may call the court to order.
The United States Court of Appeals for Veterans Claims is now in session. The Honorable Margaret Bartley presiding. God bless the United States and this honorable court.
Good morning. I'm Judge Bartley, and I'm joined today via teleconference with Judge Allen and Judge Falvey. We're here today for the matter of Luis Martinez-Bodon versus Robert L. Wilkie, docket number 18-3721. The issue before us is whether service connection can be established for a psychiatric disability based on symptoms and functional impairment absent a DSM diagnosis. Counsel for the parties, please state your name and your appearance for the record, beginning with appellant's counsel.
Good morning, Chief Judge Bartley, Your Honors. Christian McTurnigan, and with me on the line, Devora Loria for the appellant, Mr. Martinez-Bodon.
Thank you, Mr. McTurnigan.
Good morning,
Secretary?
Your Honor. Good morning, Your Honor. Lori Jemison, representing the Office of General Counsel for the Department of Veterans Affairs and the Secretary, and with me on the line is Carolyn Washington.
Thank you, Ms. Jemison. Each party will have 30 minutes to present their arguments. Mr. McTurnigan, do you want to reserve a portion of your time?
Yes, please, Your Honor, 10 minutes.
Okay, we will make that happen. Mr. McTurnigan, you may proceed.
Good morning, Chief Judge Bartley, Your Honors, and may it please the court. The board's denial rests on its determination that Mr. Martinez-Bodon did not have a diagnosis. But having a diagnosis is only one path to establishing the current disability element of service connection. In Saunders, the Federal Circuit held there's a second path. A veteran can demonstrate he has a disability as used in Section 1110 by showing his undiagnosed condition causes functional impairment in earning capacity. The Federal Circuit arrived at that conclusion independent from the orthopedic-specific regulations. The Federal Circuit looked to the underlying purpose of veterans law, the dictionary definition of the word disability, the plain language of Section 1110, and general provisions of VA law and regulation. And those specific provisions of law and regulation were 38 U.S.C. Section 1155, which discusses the concept of a disability and associates that with a reduction of earning capacity. 38 CFR section 4.1, which discusses the percentage in the disability rating schedule, represents as far as can practically be determined the average impairment in earning capacity. And section 410, which discusses functional impairment, which is the basis of disability evaluations, as the ability of the whole body or of the psyche, Your Honors, to function under the ordinary conditions of life and work.
Mr. McTornigan, this is Judge Bartley. Let's just jump ahead for a second here. Let's say we agree with you on the points that you just made. How would you actually rate the veteran's anxiety symptoms here, given that not only 4.125 and 4.130, but in addition, the actual general rating formula for mental diseases references a mental condition being formally diagnosed? That's in the 0% level, I believe. Could he ever get anything then under the actual rating schedule?
Yes, Your Honor, I believe he could. And to answer your question with respect to 4.125 first, Your Honor, so looking to the language of section 4.125, it's conditional. If the diagnosis of a mental disorder does not confirm to the DSM. So section 4.125 discusses when we're on that first path, when a veteran has a diagnosis of a disability. So if that diagnosis doesn't conform to the DSM, in that situation, Your Honor, then the examination report would need to go back to the examiner in order to provide a sufficient examination to determine that particular case. And to answer your question about 4.130 and the general rating criteria, Your Honor, again, we would argue that that has to do with that first path, the diagnosis path. And Mr. Martinez-Bodon's anxiety, that would be rated by analogy to 4.130. And so he doesn't need to have or meet all of the exact or specific criteria in order to be rated under 4.130.
And so you're not making the argument that the requirement under the general rating formula, the requirement for a mental condition having been formally diagnosed, you're not making the argument that that doesn't carry through to all of the upper levels. You're saying that when VA would potentially service connect a psychiatric symptom as opposed to a diagnosed mental condition, that at none of the levels would there be that requirement. It just isn't relevant.
I just want to make sure I'm understanding your question correctly, Chief Judge Bartley. The diagnosis requirement?
Yes, the diagnosis requirement. You're not arguing that it doesn't carry through. Like you could argue that that under this diagnostic code, Mr. Martinez-Bodon couldn't get a 0% because he doesn't have diagnosis, but that he could get one of the other upper levels. That's not your argument. Your argument is that the requirement of a formal diagnosis is completely irrelevant under the circumstances that he's operating under.
It's completely irrelevant insofar as Mr. Martinez-Bodon can have a disability if he shows functional impairment in earning capacity, Your Honor.
Okay, you may proceed.
Thank you, Your
morning,
Honor.
Mr. McTornigan. Good morning. This is Judge Falvey. I have a question about what you just said about 4.125. I agree that it begins with a conditional language if. But if there's no DSM diagnosis, then they're required to return it for a conforming diagnosis. And if the second diagnosis, the second examination, didn't have a diagnosis, a DSM-supported diagnosis, wouldn't there just be a continual loop between the examiner and the adjudicator to get to that DSM diagnosis?
I'm not sure if there would be a continuous loop, Your Honor, because if hypothetically, if an examination were to find that a veteran doesn't have a diagnosis that conforms with the DSM, in my view, that's typically when there's something that might not be sufficient about the examination. Perhaps there is a rationale lacking, or there's evidence from the face of the examination that, excuse me, Your Honor, the DSM wasn't used correctly, or something to that effect. Those are the type of situations where the conditional if would come in, and then the board or the VA would have to send that back.
I'm sorry, you're breaking up, and I'm not sure if it's me or you. But, I didn't hear the last part.
Sure. Can you hear me? Any better now?
This is Judge Allen. I can't hear Mr. McTarnigan.
Judge Falvey, neither can I.
Is it any better now, Your Honor?
Much so.
Yeah.
Okay, I apologize for that, Your Honor. If I may begin answering your questions again.
Certainly.
And again, my apologies. So Your Honor, the way that I look at that language and the way it would practically work out is if the diagnosis of a mental disorder in an examination report doesn't conform with the DSM, I think that speaks to the adequacy of the examination. And you know, maybe there's some rationale lacking. Maybe the examiner didn't consider all the facts in the record. Those are the situations where the examination would have to be returned. And in those types of situations, that would be under the first path of Saunders. The first path of how to meet the current disability element, which is a diagnosis. But if the examination is returned to the examiner, or the examiner says there's no diagnosis to be had and the examination is otherwise adequate, then the question becomes, well, does this veteran have functional impairment and earning capacity? And that's something the board and the VA can look at. They can look at the record, they can look at the symptoms, they can look at their cause and effect.
So does your argument leave any way that an examiner can say that the person has nothing wrong with them medically? It seems like it doesn't matter what the examiner says under what you just said.
Well, an examiner could opine, such as they did in this case, Your Honor, that a veteran doesn't have a formal diagnosis. And so, you know, medically, as far as there are terms to use to describe what's going on with a veteran, there might not be a diagnosis, but the inquiry for VA purposes doesn't stop there. The veteran can competently and credibly report symptoms, as he did in this case, Your Honor. The board made a favorable finding that Mr. Martinez-Bodon competently and credibly reported that his diabetes caused his anxiety. And so there are two separate inquiries: the diagnosis inquiry, which the medical examiner can opine on, and then the functional impairment inquiry, the functional impairment and earning capacity inquiry, which is an adjudication that under Saunders, VA and the board is required to take.
Okay. Let me ask you a question about your analogous rating argument. how do you rate by analogy if anxiety is specifically provided for in the rating criteria under when you look at 4.120, which only allows for analogous ratings when you have an unlisted condition? And here there's a rating for anxiety that's provided for. How do you argue that he's entitled to an analogous rating?
So Mr. Martinez-Bodon would be entitled to, an analogous rating, Your Honor, because he would not have a DSM, a DSM diagnosis in this particular case. And so what the duty that VA then has is to take a step back, look at the body, the part, I know that doesn't particularly apply to this case, but, things like the part of the body affected, what the functional impairments are of those particular conditions, and find a way when it's provided for in the schedule, which it is in this particular case, to rate that veteran.
Okay, you can continue. I'm sorry to interrupt.
No, thank you,
Actually,
Your Honor.
Mr. McTornigan, this is Judge Allen. Could I follow up to the line of questioning from Judge Falvey? So, first of all, let's assume, for the purpose of my question, that the Federal Circuit's decision in Saunders isn't limited to pain as the condition, for lack of a better way to put it. And so that decision could say, hypothetically for our purposes, any condition, and here an undiagnosed psychiatric condition with symptoms, could qualify if it meets the Saunders test. Are you with me?
Yes, Judge Allen.
Okay. So you agree also, though, that VA has the statutory authority from Congress to create regulations, right?
Yes, Your Honor.
Okay. Assume VA created a regulation that said, for all psychiatric conditions, whether diagnosed or undiagnosed, you must have a diagnosis that conforms to the DSM. Assume VA made a regulation that was absolutely crystal clear that for any psychiatric condition, a diagnosis would be required. I'm not asking you to agree that that's what VA has done in 4.125 and 4.130, but just in my hypothetical. Could VA do that in your view?
I don't think they could, Your Honor. And I think that's because, well, first, VA would need to have some, rational basis to provide that as an appropriate regulation. But Congress has mandated that the Secretary compensate veterans for diseases or injuries incident to service. And these are diseases and injuries that are incident to service, Your Honor. In this particular case, Mr. Martinez-Bodon's anxiety is caused by his service-connected diabetes.
So the reason I said this was a follow-on to Judge Falvey's question is Judge Falvey asked a question along the way that was focused on the examiner. Could the examiner do anything in the report, in his or her report, that cuts off what you're referring to as the second path? And the answer seemed to be no to that. And now it seems like there's nothing that in the regulatory state that could be done that could shut this off either. That seems to be an amazingly broad reading of Saunders because it basically precludes regulation. And so I'd like to get your response to that because that seems That seems like an exceedingly expansive reading of Saunders.
If I may answer your question about the VA examiner first, Judge Allen?
Absolutely.
And I might have to apologize if I was unclear. So practically, to use your phrasing, Judge Allen, to cut off the inquiry, a VA examiner could find no diagnosis and could also opine that a veteran's symptoms cause absolutely no functional loss. And this is something that examiners do all the time in terms of looking at impairments and effects, whether it be from a psychological disability or whether it be from an orthopedic disability, Your Honor. And so if I was unclear about that, I apologize to the court, because I do think that an examiner can provide information that the board could use to find that there was no disability, Your Honor. And the Saunders analysis, the second path, Your Honor, is only one part of the service connection inquiry. This does not eliminate whatsoever the nexus requirement as well as the in-service incident requirement. These are all areas where the VA and the board, just like they do now, could deny service connection for a veteran's disability.
If we read 4.12, this is Judge Allen again, if we read 4.125 and 4.130 in conjunction with one another, if we assume with me that we read those two regulations as requiring a diagnosis in every situation, just assume that we interpret the regulation that way, you're stuck at that point, right? Because we would not have jurisdiction to consider whether that is correct. Do you agree with that?
Sorry, I just want to make sure you know I didn't drop off the call, Your Honor. I'm thinking about your question. If I might have a moment.
Sure. I favor thinking.
I don't think we would be stuck, Your Honor. And I think that's because the regulations cannot be inconsistent with the statute. And the Federal Circuit
can I jump in? What about Byrd?
Sure.
The case Byrd, are you familiar? B-Y-R-D?
Yes, Your Honor, the periodontal disease case.
Right. I mean, the argument in that case, right, was that the exclusion of the particular type of gum disease or whatever it was inconsistent with 1110. And the court our court interpreted the regulation, but then said we lack jurisdiction to consider whether that's the case, absent a constitutional question.
Well, I see. Well, in Byrd, Your Honor, the Secretary in the rating criteria had announced that periodontal disease wasn't disabling. So it's not a disabling condition. I see that my time is...
Yes, your time is up. Let's add another 5 minutes.
Thank you very much, Chief Judge Bartley. Judge Allen, I see the distinction as being in Byrd, the Secretary had said that periodontal disease is not disabling. And so it doesn't have to provide compensation for things that do not create disability. And so whereas in Byrd, the court would have to, and similar in Wanner, in Wingard, in Marcelino, the court would have to take a red pen and delete parts of the rating schedule. And that's not what we're asking the court to do here, because 4.130 has everything that Mr. Martinez-Bodon needs to be rated by analogy for the anxiety that's secondarily related to an already service-connected disability and diabetes. And in Wanner, the court would have had to allow for 2 10% ratings for tinnitus, which the rating criteria for tinnitus explicitly disallowed. And in Wingard, the court would literally have had to rewrite the entire rating schedule every single time there was a non-compensable rating. And in Marcelino, Your Honor, the court would have had to add an obesity diagnostic code. I see these two situations as different, Judge Allen.
All right, thank you.
If there are no further questions, Your Honor.
This is Judge Bartley. Judge Allen, do you have further questions?
No, I don't. Thanks.
Judge Falvey, do you have any further questions?
No, I do not.
Okay. Thank you, Mr. McTornigan.
Thank you very much, Your Honor.
Ms. Jemison, you may proceed.
Good morning, and may it please the court. The court should affirm the board's June 2018 decision that denied service connection for anxiety. The board denied the claim because appellant does not have a current disability and thus does not meet the criteria for service connection. Initially, appellant does not challenge that he has a current disability. He instead concedes that he has symptomatology that are separate and distinct manifestations of his service-connected diabetes, such that separate ratings were warranted. Here, the court was not required to consider separate ratings because although the Secretary agrees with appellant's understanding of Copeland v. McDonald, articulated in his brief, it is not for application here. There's a crucial distinction between claims for increased ratings and service connection. Claims for increased ratings evaluate existing ratings assigned to service-connected disabilities, as the court acknowledged in Copeland, in increased rating claims when there are separate and distinct manifestations of symptoms attributable to a service-connected disability, separate ratings for those symptoms can be awarded, whereas secondary service connection compensates the veteran for a separate disability caused or aggravated by a service-connected disability. Based on the fundamental difference in the types of claims, the means of compensation for these two types of claims are not the same. Here, the issue before the board was a claim for service connection. Yes.
Counsel, this is Judge Falvey. Aren't they arguing in the alternative? They're not conflating the two. They're arguing in the alternative, right?
Yes.
Okay. I'm sorry, I must have misunderstood you.
On their briefs, yes, Your Honor, they are arguing in the alternative. Here, the issue that was before the board was for service connection, and although he is service connected for diabetes, that issue was not on appeal before the board and is likewise not before the court. In support of its finding that appellant does not have a current disability, the board correctly recognized appellant's assertion that he has anxiety and, in accordance with Gendreau, explained that while he is competent to describe his symptoms, he's not competent to render a medical diagnosis. The board's findings are supported by the evidence of record and the law. As noted previously, appellant has no current diagnosis of an anxiety disability. And while he now seeks to circumvent the diagnosis requirement that by asserting that the holding in Saunders applies, his argument fails to appreciate that anxiety is a complex condition which VA has determined requires a diagnosis.
Ms. Jemison, this is Judge Allen. Could you walk me through your basis for saying that VA requires in all cases a diagnosis? I mean, and let me just be upfront, right? I think you can get there, but you have to piece things together because there isn't something that says as clearly as I just said, in any case in which one is claiming a psychiatric disability, there must be a diagnosis. So if you had to explain to somebody why you believe, the Secretary believes, that the regulations require a diagnosis in all circumstances, I'd appreciate your view on that.
Sure, Your Honor. Our reading of 4.125 through 4.130, which is the set of regulations that deal with diagnosis of mental disorders, demonstrates that VA looks to the DSM-5 in order to rate mental health disabilities or conditions. And the basis for that is because, as I stated previously, the area of psychiatric conditions and mental health conditions is one that is so complex as to need a medical opinion or diagnosis to properly address the scope of whatever the disability is.
Judge Bartley, this is IT.
Yes, Michael?
IT. Judge Allen has fallen off the call.
Oh, okay, let's pause the argument and let's see if he gets back on shortly.
Is this Judge Allen calling back in?
It is. I just dropped off.
Okay. We're ready to proceed, Chief Judge.
Okay, Ms. Jemison, you may proceed with your argument. And before you go any further, though, I do have a question for you. And that is, would you agree with me that this rule that you're saying exists for the mental disorders rating schedule does not exist as to physical conditions? Would you be in agreement with me on that? That a veteran does not need a diagnosis of a physical condition?
Judge Bartley, I would not go so far as to say that. And the reason why is because Saunders is not I understand that the point of this discussion is the application and the potential expansion of the holding in Saunders. However, the Saunders court analysis is not a one-size-fits-all, simply because the way that the court did the analysis, the first section of the Saunders decision acknowledged that impairment must reach the level of functional impairment of earning capacity under 1110. But then the second portion, which actually dealt with whether that veteran's pain could be considered a disability, is not applicable to every single thing, that's every potential condition. The Saunders court actually recognized that there is a unique relationship between pain and the Secretary's regulatory the Secretary's regulations as far as the rating criteria in the schedule, and pointed out the fact that the regulations actually treat pain as functional impairment in several regulations. So to that extent, it does not appear, and we would not concede that Saunders can necessarily be applied to every other potential disability or impairment or condition that may be raised by a veteran.
Okay, thank you. And you may proceed with Judge Allen's question.
I apologize, Judge Allen. It's been a couple of minutes, so would you mind refreshing me of what your question was?
Sure. It was, and you were in the midst of answering it, so you might have actually answered it. It was to walk me through how the regulation, in your view, amounts to saying in every situation there must be a DSM-compliant diagnosis.
Well, Your Honor, I believe that if you looked at the regulatory history for the diagnosis of mental disorders regulations, specifically the Federal Register comment in 1996 regarding the change in language to 4.125, it belies the Secretary's intent to keep the requirement of a DSM-5 diagnosis. Everything about that regulation, and about that set of regulations actually seems to point to, in a plain reading, that a diagnosis of mental disorder is required. Specifically, even in the rating schedule under 4.130, which is the schedule of ratings for mental disorders, even for a 0% rating under the appropriate diagnostic code, a diagnosis is required.
Although, as Chief Judge Bartley noted in Appellant's argument, that's actually the only level at which that requirement is expressly stated. Correct?
Correct.
So your position would be then that it cascades upward, so to speak. In other words, it is incorporated in each higher rating by its inclusion at 0.
Yes, because once you have the diagnosis for a non-compensable, in order to get higher ratings, you've already established that you had a diagnosis, and essentially you just build upon that.
And could I ask you one question about Saunders to follow up on the question the Chief Judge asked you a minute ago?
Sure.
I understood your answer, but could you respond to this, which is that the Federal Circuit in Saunders, though, reached its conclusion by interpreting a particular word in 1110, right? And so it's difficult to read Saunders as saying that whatever it said about what a disability is under 1110 doesn't apply across the board because of the way in which the Federal Circuit engaged in statutory interpretation. You are right that it looked to whether pain was included elsewhere, but it actually specifically was defining disability. So I wondered if you could react to that in terms of your answer to Judge Bartley about the potential, my word, not yours, limitations on the Saunders analysis.
Sure. I apologize because apparently I have confused you. We don't disagree with the court, with the Federal Circuit's analysis in conclusion regarding what the definition of a disability is. My response was simply to illustrate the fact that the case as a whole regarding the analysis as far as pain as being functional impairment does not necessarily apply to every other possible condition that one could conceive of. And that is simply because pain has, as the court discussed in its analysis, pain has a unique relationship with the regulations as far as VA's disability rating regulations treat pain as a form of functional impairment. That is a unique situation for that particular issue as far as pain. I can't offhand even think of another symptom or condition that VA treats the same in the regulations, such that this analysis that the Federal Circuit performed would wholesale be applicable to it.
Thank you.
Ms. Jonathan, this is Judge Bartley. But as to what you just said, isn't it true that there are, whenever VA is rating residuals of an injury, that they often won't have a diagnosis? There will have been an injury in service, but the VA then often just rates residuals of the injury, and those may be just symptoms. Like, for example, this is a weird example, but like the gynecologic rating schedule has injury to the cervix. So I've seen cases where there was an injury to the cervix during service, and then, you know, the veteran is having pain or something. Now, that's not in the musculoskeletal system, and yet VA typically would rate the symptom that the veteran is currently suffering from due to the injury, and it may not have a, quote, diagnosis, unquote, per se. Would you agree with that?
Yes. And I think that,
and
sorry, go ahead.
Go ahead.
Well, I was going to say I agree that residuals are treated somewhat differently. However, in the context of a mental health condition, VA simply just does not do that, and that's more so because it's in recognition of the fact that mental health conditions, disorders, whatever you would like to call them, are complex and not necessarily self-diagnosable.
Okay, and Ms. Jonathan, I'm glad you brought us back onto the mental disorders theme here because I got a little off there. But you referenced earlier the Federal Register from the regulatory history from 1996. What Federal Register site were you using there?
I apologize. The site is 61 FR 52699.
Okay. And you're referring to this, what part are you referring to? I have something circled here. I'm not sure it's what you're referring to.
Okay, hold on 1 second. So in the discussion where there was a retitling of, there was some adjustments made to the regulation, and they discussed the fact that, as proposed, 4.125 would require a rating agency to determine whether a change in diagnosis is a progression of a prior diagnosis, etc. And then they further discussed that a new diagnostic term not previously available to rating agency necessarily implies a diagnostic term that has evolved since the publication of the DSM-4.
I see that section here. So they were just explaining why they weren't adding that reason, the use of a new diagnostic term, why they weren't incorporating that into the regulation.
Correct. And they also chose to leave in, the point of my reference to this earlier was they also chose to leave in the requirement for, even though the DSM obviously changes based on the American Psychiatric Association's use of it, even though that changes periodically, we, VA, that is, continues to rely upon that for rating purposes under 4.125. So that was the point of me bringing it up earlier.
Okay, but I see that this paragraph that you're referring to has a sentence that says 38 CFR 4.125A requires that the diagnosis of a mental disorder must conform to DSM. Well, it was 4 at this time. But that's just basically a recitation of what's already in the reg. And Mr. McTornigan had a response to that, which is, well, you heard his response. So does this go any further? This Federal Register, this paragraph in the Federal Register, does it go any further to make clear that his argument cannot, subsist?
I believe that it does. While Appellant has argued that there are 2 paths, I believe he referenced it as, to actually get service connection for this particular condition that he is reporting. Obviously, we don't view it as such. There's nothing in Saunders that goes so far as to say that VA cannot define what constitutes a disability. It is read in conjunction with. Likewise, there's nothing in Saunders that purports to overrule the case law that I believe it was Judge Allen asked the Appellant about with regard to Warner, Wingard, Bird, Martinez. Saunders simply defined what a disability is and also indicated that if one is to demonstrate that they have pain that reaches to the level of functional impairment of earning capacity, that that pain then may be considered a disability. As I stated before, that does not so neatly translate as to application for mental health disabilities, because due to our reliance on the fact that mental health disabilities are complex and they do require a diagnosis, any court holding that a DSM, whichever number we're on at the moment, it's 5, diagnosis is not required, would render the regulation superfluous and constitute prohibited review of what should be a disability under Warner, Wingard, Bird, Martinez. The Secretary does have the authority to create the regulations and impose such things as a diagnosis requirement like they have done here. And there's nothing, even though Appellant is seeking to circumvent that, there's nothing that takes away the right that Congress gave to the Secretary in order to promulgate those regulations.
Could you, Ms. Jemison, this is Judge Allen again. I was following your discussion with Chief Judge Bartley about the Federal Register, and I agree the Federal Register section that you read was clear. But can you point me to where in 4.125 there's that level of clarity that regulation requires a diagnosis? In other words, assume I had to write an opinion that said VA has exercised its authority to adopt a regulation that mandates that for all psychiatric conditions, mental disorders, there be a diagnosis that conforms to the DSM. Right? And I were going to cite, I was going to then have to cite the language that did that. And assume I'm somebody who wouldn't go and look at regulatory history if the regulation itself didn't point in that direction?
Unfortunately, Your Honor, the actual regulation does not state it as clearly as the Federal Register does. However, I would submit that the mere fact that they're saying that if the diagnosis of a mental mental health disorder does not conform to the DSM-5 or is not supported by the findings on the examination report, the rating agency should return the report to the examiner to substitute the diagnosis. I believe that if you actually rely on that requirement in and of itself, it is extremely suggestive of the fact that a diagnosis is required.
So do you think 4.125 is ambiguous?
No, only because on its face, it can be read the way that I just stated. I don't see where you can take away the fact that it's saying that the diagnosis must conform to the DSM-5. There would be no reason to say that something needs to conform if it wasn't required.
Well, I suppose Mr. McTornigan might say, but that is only about the, quote, path in which you are seeking service connection based on a diagnosis. If you're seeking service connection not based on a diagnosis under the Saunders rationale, then the argument might be that 4.125 is simply irrelevant because it goes to situations in which there is a diagnosis. And while you think about that, let me just tell you, for me, this is the absolute central issue in the case. Because if VA has adopted a regulation or connection of regulations, right, 4.125, 4.130, that require a diagnosis in every case, I think our work has to be done because of the jurisdictional problem. If VA hasn't done that, then we are really confronted with the scope of Saunders.
Just so that I am clear on your question, would you mind repeating again?
Sure. It is your interpretation of 4.125 is it wouldn't make any sense if there wasn't a requirement for there to be a diagnosis because it's saying return it if it doesn't conform to the DSM-5. I understood Mr. McTornigan's argument to be, yeah, but that only deals with a situation in which there is a diagnosis. And it's saying if you've got a diagnosis, it's got to conform to these boxes or you send it back. If there is such a thing as the Saunders second path, then a regulation talking about what a diagnosis must contain would be irrelevant to the situation in which no diagnosis was required. That's what I was trying to get your response to.
Okay.
That reading of 4.125.
Well, Judge Allen, I guess it would hinge on if you believe that there's a second path under Saunders, which the Secretary does not. We would submit, first of all, there's a couple of flaws in Mr. Matarnigan's argument in that regard. First, as I stated previously, the analysis that appellant is seeking to use is unique to pain, not the analysis dealing with what constitutes a disability under 1110, but the analysis as to under the second portion that dealt with the pain as a disability. Further, while we have not necessarily gotten into the facts of this case, this particular appellant, there's no evidence provided by appellant or any place else in the record that demonstrates that even if appellant was successful in this argument, that he should be he should be allowed a path that is not in existence with the law right now, that he has demonstrated at all that he reaches functional impairment of earning capacity. He's not asserted it, and it's no place on the record where it could be read that way. But more to the point, Saunders shouldn't be expanded to apply to things that were not the intention of the court in that case. There is nothing to indicate that the court in Saunders intended to overrule the prior set of cases that just alleviates the Secretary of the authority to require diagnosis or determine what a disability is within the scope of the regulations. It simply provided guidance on how to get there.
Counsel, I see that your time is almost up. Let's add 5 minutes.
Thank you, Your Honor. Further, if you read into the fact that the Fed Circuit omitted any declaration that pain has to be considered a disability, that we believe is intentional because it's prohibited, as you noted before, absent a constitutional issue. And the court is prohibited from determining or reviewing what should be considered a disability. That's exactly what Appellant is asking you to do here, and that does not fall within the boundaries of the existing case law, statutes, and regulatory interpretations that the court is bound by. So to answer your question, I don't think that Appellant's reading of 4.125 is accurate or comports with what is already the existing framework. And Saunders simply just is not a one-size-fits-all that you can pick up and plop any disability or condition in and achieve the same result.
Ms. Jemison, one last question about jurisdiction. This is Judge Allen. You agree, though, that we have jurisdiction to interpret 4.125 and 4.130 to the extent that we need to decide whether they individually or collectively require a definite a diagnosis in every case. You agree we have jurisdiction to do that, right?
Yes.
Great, thanks.
If there are no further questions by the court.
Judge Allen, do you have any further questions?
I don't. Thanks, Chief.
Judge Falvey, do you have further questions?
I don't. Thank you.
Well, then
Okay, thank you.
The Secretary would submit that the court should affirm the board's decision. Thank you.
Thank you, Ms. Jemison. Mr. McTornigan, you may proceed with rebuttal.
Thank you, Chief Judge Bartley. The overall theme of this case is that Mr. Martinez-Bodon is entitled to compensation for his anxiety because it was caused by his service-connected diabetes. Feelings of anxiety and explaining those aren't complex. The board actually favorably found that he, Mr. Martinez-Bodon, who submitted lay evidence, a lay person, that he was competent to report that his diabetes caused his anxiety. VA has a duty to find a way to rate Mr. Martinez-Bodon for this symptom related to a service-connected disability, and that's Morgan, Your Honors. Holding that one path to establishing a disability is that a condition causes functional impairment in earning capacity is opening the door just a little bit to letting adjudicators rate some veterans with non-diagnosed conditions, but only when those conditions cause functional loss. This is the path that the adjudicators must follow, one of the paths, because the Federal Circuit's definition of a disability under 1110 was completely removed from its discussion of what functional loss and orthopedic disabilities are. And it doesn't remove the other elements of service connection that veterans need to show before they can get service connection for those disabilities, the nexus in the in-service incident. And if there are no further questions, Your Honors,
Well, Mr. McTarnigan, this is Judge Bartley. So the Secretary's Counsel referenced, Warner and Wingard and Marcelino. Why is this case different from those?
Certainly, Your Honor. So to answer your question, Chief Judge Bartley, about Warner first, that case dealt with the rating for tinnitus, and the veteran was arguing against the fact that there's only a singular 10% rating for tinnitus available. And in order to prevail, the court in that case would have had to take a red pen to the actual diagnostic code, to the code of federal regulations, to allow for what the veteran was saying is required by law. Wingard is a very similar situation, Your Honor. 0% ratings, in that case, the Federal Circuit said that a 0% rating is fine, that the Secretary is allowed to have regulations with 0% ratings. There are many 0% ratings in the rating criteria. To have Mr. Wingard prevail, the court would have had to literally delete every single 0% rating in the rating criteria. And then I believe, Your Honor, you also asked about Marcelino. I just wanted to be clear on that before I continued.
Right, I did. Yes, I did, yes. So
thank you, Your Honor, for the clarification. In Marcelino, there is no diagnostic code for obesity. In that case, the appellant was asking the court to add an obesity diagnostic code. And this case is different from those cases because the diagnostic code to be rated by analogy, 4.130, already exists, Your Honor. We're not asking the court to change the rating criteria 4.130. We're not asking the court to delete a certain section of that diagnostic code or take a red pen to it, because everything that the court needs to apply the Federal Circuit's holding in Saunders is there.
And so when Warner says, and I think that some of the other cases also contain some language that's fairly broad, Warner says the language of 7252B removed from the Veterans Court's jurisdiction all review involving the content of the rating schedule and the Secretary's actions in adopting or revising them. And then mentions the exception, of course. That's very broad language. I mean, just talk to me about how this case doesn't fall into that.
Certainly, Your Honor. I don't think that this court needs to revise the rating schedule at all, Your Honor. And I think the facts of Warner and some of the other cases that we just discussed, Chief Judge Bartley, where the court did find that they did not have jurisdiction, the way that the veteran would need to prevail is entirely different than in Mr. Martinez-Bodon's case, because that language, the review of the rating schedule in Warner, would have required the court to change the diagnostic code. It would have had the court to revise literally with its own hand a regulation that was promulgated by the Secretary. And that's just not what we have in Mr. Martinez-Bodon's case. In Mr. Martinez-Bodon's case, because of the Federal Circuit's definition of a disability relying on the plain language of 1110 and looking to VA's duty under Morgan to exhaust all scheduler avenues to rate a veteran, and the Secretary's duties to rate a veteran who has a disability due to the service, due to their service, there's no requirement to touch the rating schedule or revise the rating schedule at all, Your Honor.
Thank you, Mr. McTarnigan.
Thank you, Chief Judge Bartley.
Judge Allen, do you have any further questions on rebuttal?
I don't. Thank you.
Judge Falvey, do you have further questions?
I don't. Thank you.
Okay, thank you, Mr. McTornigan.
Thank you, Your Honors.
Well, we thank the parties very much for your arguments. The case is submitted for consideration and the court is adjourned.
The court is in recess.